Okay, let's dive right into this explainer. Today, we're exploring a fascinating constitutional showdown. Imagine this: government bureaucracy colliding head on with a rapidly approaching hard legal deadline. We're looking at a pretty remarkable 2005 judgment from the Constitutional Court of South Africa. Now, on the surface, sure, it looks like a case about a local law dealing with stray animals. But at its core, it's a high stakes drama about judicial power, administrative failure, and the incredibly delicate balance a court has to strike when the government simply fails to do its job on time.
So, picture a ticking clock, counting down to this exact number, 15. That's just 15 days left before a massive legal deadline completely expires. That is the razor-thin margin the KwaZulu-Natal Department of Local Government and Traditional Affairs left themselves with when they finally approached the Constitutional Court. I mean, they've been given a full year, a whole 12 months to fix a broken law. And yet, with essentially 2 weeks left on the clock, they had to throw their hands up and admit they just weren't going to make it. Which brings us to a really compelling question. What actually happens when the government completely misses a constitutional deadline? More specifically, what exactly does a Supreme Court do when they're forced into a corner, having to choose between punishing government delays and preventing total, widespread societal chaos? Do they just strictly enforce the law and let the chips fall where they may? Or do they grant a reprieve to protect the everyday public? To figure that out, we need to look at Section 1, the 12-month deadline. To understand the absolute panic of September 2005, we actually have to jump back 12 months to the original judgment in the case of Zondi versus the MEC for Traditional and Local Government Affairs. Here's a setup. Back in 2004, a woman named Mrs. Zondi successfully challenged the KwaZulu-Natal Pound Ordinance of 1947. And the court actually agreed with her. They ruled that several sections of this old law were totally inconsistent with the Constitution and declared them invalid. But here's the catch. They didn't just strike the law down instantly. Instead, the court gave the provincial legislature exactly 12 months to replace it. And just to make sure things didn't completely fall apart in the meantime, they put temporary interim rules in place, like requiring a magistrate to actually authorize any animal sales. This was crucial to protect both the landowners and the stock owners. Now, to really get why this matters, we have to grasp this specific legal mechanism. Think of it as a vital constitutional grace period. In legal terms, it's called a suspended declaration of invalidation. It's actually a super pragmatic tool. The court basically says, okay, we acknowledge this law is unconstitutional, but they also know that erasing the law overnight would create a massive, dangerous legal vacuum. So they just hit pause on the invalidation. They're essentially telling the government, hey, this law is broken. You have exactly 12 months to pass a new one. Go. Which leads us straight into Section 2, a race against time. Because, as you can probably guess, giving the government a grace period is one thing, but them actually meeting that deadline, well, that's quite another. What follows is literally a masterclass in how bureaucratic friction can just eat away at the most generous of deadlines. Let's look at this staggering progression of delays. Month 1, October 2004, the judgment drops. Okay, they have a full year. Easy, right? Well, by month 5, March 2005, internal deadlines to draft the new legislation are already completely blown. By month 9, July 2005, they are only just formally appointing an external service provider to help draft the laws. This incredibly sluggish pace just burned the clock right down until a panicked extension request was filed on September 23rd. That is a mere 15 days before the deadline. And to make matters worse, they filed it improperly, without even giving the correct notice periods for the opposition. So what on earth went wrong? Well, the government's excuses were this messy mix of policy pivots and just sheer disorganization. First, an original draft bill proved too controversial, so they had to completely scrap it and start over. Then, a new MSC was appointed, plus a new departmental head, alongside some massive restructuring within the department. But here is the absolute kicker, my personal favorite: a lost floppy diskette. Yep, you heard that right. Part of the delay in getting the court filings sorted was actually blamed on a missing floppy disk at the state attorney's office in Johannesburg. Justice Gungobo, who wrote the judgment, absolutely scolded them for this. He pointed out how deeply inappropriate it was to just casually offer up such an absurd excuse verbally in court instead of actually documenting it in a sworn affidavit. Moving on to Section 3, can courts change minds? With time rapidly running out, the court found itself facing a deep constitutional dilemma about its own authority. I mean, can a court actually go back and change a final order it has already made? This situation perfectly illustrates the tension between two huge legal concepts. On one hand, we have the incredibly rigid common law rule of functus officio. Basically, this is the doctrine of finality. Once a judge makes a final order, their job is done. Their authority over that specific matter just ceases to exist. And the logic there is sound, right? Citizens and governments need absolute certainty in the law. You can't have things changing every 5 minutes. But on the other hand, we have the Constitution, specifically Section 172, which explicitly demands that courts make orders that are just and equitable. Ultimately, the court concluded that a suspension period is, by its very nature, based on the facts they had at the time. If dramatically new facts emerge, say a government completely failing to meet its timeline, the court absolutely has a continuing just and equitable power to step back in and vary that deadline to ensure justice is actually served. Now, here is the crucial takeaway. While the court recognized it did have the power to extend the deadline, Justice Ngabo firmly laid down the law. He noted this power is absolutely not a free pass for disorganized governments. It should be very sparingly exercised. The principle of finality is vital for the rule of law. A court just cannot be a safety net for bureaucratic incompetence. Extending a deadline is an extraordinary measure, and it always has to be balanced against society's need for legal battles to finally come to an end. Let's look at Section 4, the cost of legal chaos. To truly understand why the court even considered bending its rules for this extraordinary extension, we have to look at the literal stakes on the ground. Because this was not just some dry paper exercise happening in a courtroom.
Remember, the law we're talking about regulates pounds. It dictates what happens when livestock trespasses onto someone else's property or strays onto a public road. If that 12-month extension just expired without a new law in place, those vital interim rules would evaporate overnight. We wouldn't just be looking at a theoretical legal vacuum. We'd have wandering livestock utterly destroying crops and livelihoods. We're talking massive, potentially fatal safety hazards to drivers on public roads. It would create an immense physical and financial nightmare for literally everyone involved. Landowners would completely lose their legal power to quickly impound trespassing animals, and stock owners would lose their crucial legal protection against having their animals unfairly seized and sold off. It would be a disaster. Justice Ngabo really laid out the grim reality of rejecting the extension with a stark warning. If the court stubbornly refused the extension just to punish a sluggish government department, the people who would actually suffer the consequences would be the everyday public. He warned that chaos and lawlessness would reign on the farms and roads of KwaZulu-Natal. You wouldn't be protecting the rule of law by denying the extension. As Ngabo so forcefully put it, the rule of law would be the first casualty. And that brings us to Section 5, the final verdict. Faced with this impossible choice between punishing obvious bureaucratic incompetence and protecting the public from absolute chaos, the court had to make a highly pragmatic decision. To even justify getting an extension, the government really had to prove they had a viable, solid plan this time around. So they outlined this escalating mountain of work that was still required to pass a new, constitutionally sound law. First, draft the bill and publish it for public comment. Then, submit it to the Executive Council for in-principle approval. Next, refer it to the Portfolio Committee for a super detailed review, which might include public hearings. And finally, get ultimate approval from the provincial legislature. They estimated this whole rigorous process would take roughly another 12 months, frankly acknowledging that, hey, the legislative process is complex and sometimes completely unpredictable. So the final ruling was this fascinating balancing act. Acting kind of like a strict but very practical parent, the court heavily scolded the government. They dragged the MEC for waiting until the very last minute, for offering up those incredibly vague excuses, and for not even properly bringing the original court order to the provincial legislature's attention. But, at the end of the day, reaffirming that their highest constitutional duty is to make an order that is just and equitable, they prioritized the public. To avert total societal disaster, they went ahead and granted the 12-month extension, firmly pushing that new deadline to October 15, 2006. As we wrap up this explainer, I want to leave you with a provocative thought. Because this case, it isn't just about stray cows and lost floppy disks. It is fundamentally about the delicate balance between the strict finality of the law and the messy, often chaotic reality of governance. When an administration stumbles, who should really pay the price? If courts rigidly enforce every single deadline, society might literally fracture. But if they always bend the rules, well, deadlines lose their meaning entirely, right? So, ask yourself, when exactly should the strict rules of the law bend to prevent societal chaos? It's a question every democracy eventually has to answer. Thanks for learning with me today.